another edition of Ask Michael Ehline. This is where I teach people the law in an unorthodox manner by using examples that we see in the news, case law briefs, but it's all about exposing the Leviathan and its instrumentalities and taking back your rights. Know the law and mean to keep it well. Come here to learn from an expert to know your right. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. Hey guys, so I'm sorry that it took me so long. I have been in hearings all day. As you guys know, I'm attorney Michael Ehline. Thanks for joining the show. I am a California and Texas personal injury attorney, but I've been following the story of Ehline Myers because I have a lot of respect for pro per litigants, pro se litigants. I used to be one before I became a lawyer, and I am a big time proponent of natural law and obviously the right of free speech and press and holding the government accountable. And I've been following this. And again, I'm not licensed to practice law in Arizona, so I'm not giving you Arizona legal advice, but I'll just share with you, what I've learned about the case and about what I know. And I'm going to go ahead and this is a public service, has the Ehline Myers hearing. And so it's just the audio. So I'm going to basically tell you what's going on from what I know right now. And so what I know right now is it looks like there was a hearing. Apparently Ehline got like 14 felony charges and a bunch of misdemeanors mailed to him as a summons. And then he appeared in court. I think he filed what's called the Ferretta motion. In California, we call it a Marsden, but it's the same concept where you don't want an attorney, you want to represent yourself. And so I think that was actually granted. But when he showed up, he noticed, I guess, some bicycle cops in bicycle shorts outside the court with some kind of paperwork with his name on it. So he already could see the writing on the wall that he was going to be arrested. And so he brought that up in the hearing that, hey, I'm going to be arrested, and he tried to get relief from the judge. Apparently that didn't work out, but I guess they allowed the other attorney, because he can't represent himself from jail, which obviously is the idea, right? I mean, if you're the prosecutor, you don't want the guy to be able to do a good job, keep him locked up, right? A lot of people say that anyways. So that's the strategy, right? So apparently what happened here is the attorney that he has now that's no longer his attorney was made what's called a friend of the court. So he'll be able to assist Ehline while he's locked up. So Ehline went outside, and of course he got the torture cuffs put on him. He got thrown in jail, and there's a hearing tonight at 7:00. And so I'm going to go as long as I can. I was going to cover the Alex Jones deposition tonight, but unfortunately this kind of overrides that. So we'll get into that another time. Thank you, Ryhoot, for joining. Thank you, Dolores Claiborne. Thanks, BZ Watchdog, for showing up. Jody Shiloh, thanks for showing up. And let me see here. Torque Auditor, Bad Day in Court. Sounds like it. Now, I was able to listen to just a small portion of the hearing. And again, it's audio, so I don't want to bore you guys. So but I'll try to narrate as best I can based on what I understand. Again, I'm not an Arizona attorney. I'm not licensed to practice law in Arizona. So I'm just bringing this to you to discuss general legal principles, what they would teach you in law school, as well as just as a citizen journalist myself, just cover the story. Because just from my personal perspective, I think that he's getting shafted. And here's the deal. He filed before we go any further into the video, he filed what's called an anti-SLAPP. Okay. And because I used to do a lot of defamation law when I first started out in appellate work, I didn't realize that Arizona had a criminal anti-SLAPP. So typically, your SLAPP, anti-SLAPP is going to be civil. All right. So typically you sue someone for defamation because you're trying to silence them. And so we call that as lawyers a strategic lawsuit against public participation, SLAPP. Then anti-SLAPP is where you slap back, right, against them and say, no, I'm slapping you back, mofo. You're trying to silence my speech, and you go after him for a bunch of money. And if you have a lawyer, you can go after him for attorney's fees. And I've gotten, up to $100,000 in attorney's fees or more granted to my clients in similar cases, but that's civil. Now in criminal, he's arguing the same thing, that the prosecutor, apparently the city attorney, is the husband of one of the so-called victims, right? And they're all public officials. They work for the government employees, right? The same people Doge would go after. And they don't like guys like Lane. They don't like patriots. They don't like guys who don't support the administrative state, who don't support the democracy. We know that, right? You know, they live, a lot of people call them parasites, right? They live off the taxpayer. A lot of people do call them that are on my show quite a bit. So that's sort of like the windup. Okay, so he has filed this anti-SLAPP, and he has shown up in court. And now, of course, outside the court, he gets arrested. And I guess a small foundation, from what I know, because it's not a lot, is the state is accusing him of harassing this woman. And of course, the city attorney husband is alleged to have forwarded these charges to the county prosecutor. So a lot of people are arguing that it's unfair, because they're using their government position. Well, we've heard similar stories. We know that, what was that one? Peter Strzok and Lisa Page, they're the ones who said they had an insurance policy to keep Trump from getting elected. And now we found, that this big paper trail leading back to the Democrat Party and George Soros. And basically the left has infiltrated all of our government agencies. And now we're seeing a similar thing where I guess Lane has made such a big stink about things that it appears that they want to silence him. And so his approach was to slap back and file an anti-SLAPP. And then so many people are saying in retaliation for that, now he's been arrested. So at 7:00 tonight, what you want to do is follow, and I'll give you the link and everything. You want to follow. This is a public service. So I'll go, for as long as I can into the hearing, what happened today, and just tell you what I think, give you my 2 cents. And then I'm going to refer you guys over to watch This Is a Public Service. But SW Observer, good seeing you. CFW questions. Let me see here. BZ, Cops are 5150. Republic. Yes. So that's kind of what's going on. So let's go ahead and start listening to the actual hearing. And again, it's probably going to be all black, like my women. Just kidding. And we'll go from there. But let's listen to what happened today. It's an hour and 55 minutes, so we're not going to get through the whole thing, but we'll do as much as we can. Hopefully you'll be able to hear it.
All right.
So here's the court starting. So obviously there's somebody in their audio recording. I guess it's still legal to audio record.
Let's go on the record in the matter of state of
Right, let's go on the record in the matter of Arizona versus CR 20510 CR 2060 defense motion to defense motion to represent the status conference. Part of the status conference.
Rachel Stiles for the state. Rachel Stiles for the state.
This is William Parham. Mr. Myers, something came up. We need to address.
Hope that
I want
doesn't happen all the
address something
time.
else. Okay, I want to address something else. First of all, the first thing I'm going to announce is streaming. But then I want to address Joey Payne of the Phoenix Times.
Can you guys hear?
They have
Something's going on here.
I was
man.
in the
I'm getting
impression
like major.
I was in the
feedback.
impression when this was from the Phoenix New Times, and that's how I identified it yesterday. Maybe I didn't read it close enough. And then yesterday during the hearing, Mr. Myers had said that he owns this. I looked up the Phoenix Times. There is a website called the Phoenix Times. It basically links to other news articles and posts press releases. I couldn't find any Joey Payne associated with that. And our public affairs representative indicated that the person here today is from RP Media, which is a different company. So I'm not at all certain who's actually making the request. And without that, I'm going to have a hard time to stream this. So Mr. Parvin, I'll start with you first. Your position on this.
Well, My position is, again, we've already ruled because there's no victims, or the court ruled because no victims here, there are less concerns. There's no objection to streaming. I think the court already prohibited Mr. Myers from using his own personal device today, under the understanding that others would be able to do it that would not have as much interest, I guess, in the case. Mr. Myers was allowed.
So just to give you the narrative, so there's a rule in Arizona court that allows people to audio record. And so obviously Lane Myers took advantage of that. And now the prosecutors are infuriated because they don't like it that he's streaming from court and basically trying to hold the government accountable. In a nutshell, they don't like it. So now you have RP Media, I wonder who that is, who's in their audio recording. And now in California, it's pretty much impossible to record unless you have all these press credentials. It's crazy. But in essence, our original Constitution and Bill of Rights never said you got to have got to work for CNN or some far left organization to be able to record in court. It was always we, the people, as individuals, that had the right to hold the government accountable. And courts of record are very important. Give me a bunch of ones if you agree. So that's sort of the windup. So the court's literally having to rule on whether or not someone can audio record. And of course, the argument that the prosecutors make, who don't want you to know what they're up to, right, will always say things like, oh, there might be a victim, we got to make sure to protect the victim. But this is an audio recording, guys, okay? So I think it's pretty pathetic. Anyways, let's go.
Speak on his behalf, even though I have not officially withdrawn yet, for the court. Let Mr. Myers answer this question.
Okay, Mr. Myers, do you want to answer this?
The question, yes. Phoenix Times is a DBA. It's just a website name to,
Yeah, it's owned by. Hold on, it's owned by Newsmatics Inc. Is that correct?
It's
In Washington D.C.
You pay them to host the website.
Okay.
To host the website.
Okay.
It's just to do ads and stuff so that you have a website people can go to and stuff like that. And because it's out of Phoenix, they had a local guy. It's just like having an independent contractor.
Yeah.
Okay, but I don't really know who this is, and I evaluate
Who's here today or in
who
general?
In general, who the Phoenix Times. I don't. I have to evaluate.
Media company.
It's your media
I
company.
own Freedom Productions LLC.
Okay,
My
and
DBAs.
all right, so this is your company basically.
It's a DBA, but it's not an LLC.
Okay.
You don't have to have it registered to use it. It's so that we have.
But your company basically opened this website as the Phoenix Times.
My company, Freedom Productions.
Yeah.
Which is multiple companies under it, started that website so people had a website to go to, and we could sell ads so that we could have the email Phoenix Times and all that. In exchange for that, that company puts you out there, and then they run those ads on there, and they get ad revenue.
Okay. All right. Let me.
We do the stories and that kind of thing, but it's just like a website hosting thing. You know what I'm trying to say? You pay them to market you.
So basically, what it sounds like is that the judge is trying to establish that these companies are really just Lane Myers. And I guess the reasoning would be, if it's Lane Myers, well, he's the sacred cow. He's not allowed to record. So I would guess that then he would be prohibited, because the prosecutors, I guess, who have a wife that feels threatened by him, who's a law professor or something. I mean, I don't know. Tell me in the comments. I don't really know exactly what's going on, other than that they're trying to silence him in particular. So let's hear what the judge has to say.
All right. Let me hear from the state. Ms. Stiles, your position?
Right, Dolores.
So
Yeah.
who do we have here today?
Somebody who says they're from RP Media, which my understanding is a contractor that has been contacted by by somebody to cover this. The Phoenix Times is not an entity. My understanding is just a website that the defendant opened.
Okay.
Well, the rule's just very clear that there has to be that notice given to the court prior to. So if we're getting somebody else who's filming who didn't provide the notice to the court, they wouldn't be entitled. We're still live streaming, so the recording's still being put out in the public. But if this isn't the person who requested, this company isn't the one that requested the permission, then I think under the rule they're automatically denied. It's my understanding from the rule.
Okay, but I think that's for video recording, right? I think audio recording, all you have to do, based on my understanding, is simply provide notice that you will be audio recording. I don't even think that there's a hearing that's necessary. Give me a bunch of ones if you guys agree with that. Or somebody throw me the law on the side who's a lawyer or somebody who's a resident of Arizona who knows more about this.
I'm going to reverse my ruling from yesterday. This is not what I thought I was approving, and I find it very confusing.
Can I say
And-
one last thing, sir?
Yeah.
Even though I'm not to persuade you to overturn it, but just to clarify something.
Make your record.
Yes.
Go ahead.
Is there a better way you want us to file that in the future? Because it's ultimately Freedom Productions doesn't have its own website to give you.
Okay. You can file something. I'm not going to give you legal advice. I just did not understand who was making the request, and it was very confusing to me. And I'm concerned about the nature of the charges in this being a harassment case, about who's doing what. So I'm not going to allow.
Of course,
I'm
they
going to deny
denied
that
it.
for today's hearing.
Can I say something, Your Honor?
Yeah, hold on. There were a couple of things I had on my list here before we.
Okay, but I wanted to add to that could change the prior ruling, maybe the reason
Okay.
for as well. Your Honor, we still believe that under the 122H,
Yes.
Mr. Myers should at least be able to use his personal audio
Yeah.
recorder to record the hearing for his own purpose. I think that's the rule permits. The reason we
For now.
didn't object more at the last hearing is because the court was going to allow a separate company to essentially film this. We would have concentrated more on that objection and perhaps Mr. Myers would have filed more on why 122H would allow him to do audio recording today. That's a concern because the only reason we accepted the court's ruling without further argument, or Mr. Myers would have filed more motions, was that he understood the court was going to allow some sort of video today. I don't know what YouTube is showing. I don't know where it's being live streamed, how people can access. I'm just not familiar with it. But I think Mr. Myers at least would like to use his personal recorder 122H to give notice about it and be able to record this hearing.
I deny that. So let's.
Why? What is the basis
One
to
thing I want
deny it?
to quickly say, don't forget, is Mr. Myers filed a motion to exceed the page limit, which I'm granting. And that's for his anti-slap motion. So
Thank you, sir.
you didn't have an order, so I just want to do that on the record. All right. Next.
Yeah, and that's pretty typical too, because under Balistreri versus Pacifica, page count is more procedural, right? So judges give a lot more leeway and deference in that case. But if it was a substantive issue, they wouldn't. Now, me personally, if this was in California and there was a rule like this, I would probably want to appeal that or file a writ for the judge not allowing me to use an audio recording device. There should be no problem with laying audio recording. I find it to be, in my opinion, quite petty. It should have been allowed, in my opinion. What do you guys think? I want to hear what your comments are.
Before we address the defendant's motion to represent himself, Mr. Parvin, you wanted to say something.
Yes, it's come to my attention that rather than file all charges at once, where Mr. Myers would, I guess, be bailable as a matter of right, this whole situation seems to be piecemeal filing. There are Tucson Police Department officers, I don't know if they're in this room now or if they're waiting outside, ready to arrest Mr. Myers on new charges that will be consolidated with this court, which will therefore deprive
I
Mr.
agree with
Myers
you. Speak
opportunity to
life,
respond and represent
absolutely.
him pro se, therefore forcing me to be on this case against Mr. Myers' wishes to represent himself. I ask that we be.
So Speak Life in the Garden really, it makes a valid comment, which I put up there for you guys to read. The court's already videotaping. There really shouldn't be any problem with Lane being able to audio record. And if I was the judge, I would just be rolling my eyes at the prosecutor. Like, how petty of you to not allow him to audio record when we're already live streaming this. I mean, really, guys? I mean, I'm overruling that. That's petty. That's absurd. We're here right now for a hearing on whether or not Mr. Myers can represent himself. There's no victims in the courtroom. This is crazy. This is overreach. This is like, you guys have way too much power here, way too much authority, and I'm going to pull it back because it's my job to be a neutral arbiter of the facts and the law in this case.
If the state seems to know what's coming, that since this court has jurisdiction for these new charges, I ask that we do an initial appearance today immediately and set release conditions so that Mr. Myers can continue to represent himself, because otherwise we're going to have a real problem after this court grants this motion, because now he needs new attorney on the new initial appearance. And then I'm back in this with the same kind of Feretta motion doing this again. We got a real problem.
Feretta.
Well, so we have a CR pending now. Defendant's been held over, and I'm going to rule on that. I don't know what's going to happen if they're going to file an amended indictment, if there's an arrest and they want to go forward on an amended indictment. That there's nothing pending that I could. I understand your issue, but there's nothing there's nothing pending that I could address.
Well, wondering if the state has any information at all, because considering there's an arrest, that he's going to get arrested on new charges. I just talked to the officers. So that's kind of it's going to pose a real problem here. How is Mr. Myers going to respond to motions pro se? At the same time, how am I going to be withdrawn? He needs representation. And then if there are new charges on new arraignment, the court's going to have to reappoint me again and do this all over again. So again, does the state have any information of all? Because I mean, these officers seem to have information.
Ms. Stiles?
Great arguments, by the way, by his attorney. That's pretty impressive. So he's been appointed by the court to represent Lane, but Lane's filed a Feretta motion because he wants to represent himself. So what is the state's answer to that? Let's throw this dude in jail. Let's show up at the court. Let's intimidate him and his attorney, stand outside the courtroom with paperwork. I mean, come on, guys. I mean, how obvious, how much more obvious can you get that there is probably an excess of state power at play here to try and intimidate Lane and anyone else who's standing up for their rights? And that's why I believe in recalls. I believe in recalling public officials, recalling anyone who goes against our Constitution and our Bill of Rights. And this is an example of why we need to start doing that, because we saw what happened with the efforts to overturn what many people believe was a stolen election, right? Judges just shut it down, even in the face of overwhelming evidence of widespread fraud, just shut it down. And then, of course, PMS, NBC, and Communist News Network came out, CNN, and tried to make it sound like, oh, anybody who disagrees says this was a stolen election is a crazy person, right? The same kind of deal. Here we go.
Your Honor, I notified defense counsel yesterday that there were likely new charges coming.
Okay.
And so this defendant just happens to be committing new offenses. And so he faces, just like anybody else who would be ongoing criminal activity would be facing new charges. That's the position he's in. And
Let me ask this. If that occurs and it proceeds and there's an indictment on the new charges, would that be in this CR or a new CR?
it would be a new CR.
Okay.
It's a
And that would be
separate case.
assigned to me because typically we assign all matters to the same Superior Court judge. So, but
Now, my understanding of a CR, at least in some jurisdictions, that means criminal referral. Can somebody tell me in the sidebar who is in Arizona what CR means? I just want the audience to kind of know what's going on with terminology.
those aren't pending. Would you agree with me that there's nothing I can take action on with respect to that? It's speculative.
There's nothing that he would have to go through the process, but there's nothing currently that would be in front of the court for the court to be able to do anything on.
But the new charges wouldn't affect these pending charges, correct?
Correct.
Okay.
It would, Your Honor, because it's going to affect potentially his bail eligibility, and that's a problem if there's no basis for the new charges. That's the whole point of Mr. Myers' slap motion.
Criminal rules?
I would have filed it slightly differently. Maybe I would have done a motion to dismiss under the grant or motion to remand once the grand jury transfer comes in. There are things I would have done differently, Mr. Myers, and I would have taken more time to do it. That's the reason I have to withdraw, so Mr. Myers can do everything the way he wants, and he may or may not be, right or wrong, doing it different than me.
Right.
But that's a real problem because if I don't know where the officers are, they were here. I don't know if they're in here now, can give information. But if this court proceeding concludes, we go out there and Mr. Myers gets arrested, brought into custody. He needs a new initial appearance. I don't know when that's going to be. Obviously, the court's going to need back in on it. Are we going to have to reappoint
Not too much,
again
Ann.
and then go through a new withdrawal? And then I'm wondering, at this point, I'm just trying to think for.
Well, we could do a couple things. We could put off your motion if you'd like to withdraw. I mean, that would be the.
But then my
He needs his motions
hold
filed. Sorry.
on. The court system goes in steps, and we're at one step right now. I don't know if he's going to be charged in a new case or not. I have no information on that. But if you in consulting with your client would prefer to stay on now, and then we could reset this, or we can go forward. That's your choice.
I think what's going to happen as
You guys hear this
crazy as
still?
This will be. We'll proceed today with the motion to withdraw and Mr. Myers' request proceed pro se. My understanding is all of his motions have been filed, which will prompt the state needing to respond, and that way at least everything's filed.
What's up,
And
Brett? Good seeing you.
I'm guessing I will be notified of the new initial
Very good.
appearance. Now, again, I have a calendar as well with my other, OCAT cases, and I'll have to rearrange things to try to come to the new initial appearance. I'm guessing I'll be appointed again, and then on whatever new cases, We'll have to be right back here on the new case and
Yeah.
do this again. I guess it needs to be done twice, is from what the court's
Sure
understanding.
does, Stephen.
But we'll do this
Hey,
today. We'll get through it. And Mr. Myers, I will be with you. We'll talk to the officers and find out what's going on before you are arrested.
Yeah, I think that, again, we have to concern ourselves with what is currently pending, and I can't speculate as to, the different steps in the criminal process, and I don't get the case back until the defendant is held over if there's a new case. So, I think
this is just a very unusual case.
They
Your
did
Honor.
this on
Hold on.
purpose.
I'm
Hold-
explaining to
hold-
the court
hold-
why this. I understand everything the court's saying. I just hope the court understands how rare this type of situation is.
it's
Sounds like a
unusual,
big
but
show of
people actually
force.
pick up new charges all the time. It's kind of a.
But I
it's a-
haven't done anything.
I
ho-
understand. But I'm saying it's unusual where a person wants to represent themselves and
Right.
respond to motions, but normally I should say the same attorney can help them while they're in custody.
They're doing this so I can't type at my computer. They just want me away from my computer.
That's true.
All right.
I would say that's a
I'm
fair.
not-
Your record,
that-
forget
we're not
your
that, that's not our issue today. Today, our issue is whether you want to represent yourself. So, and I know the last thing I wanted to mention is that, Mr. Myers, I understand that when you're filing things through our e-filing system, that you're having a hard time marking action for a copy to go to chambers. And we checked on that, and there is only one filing system, and it is possible to mark action by the division.
I
So,
don't know where that is on there.
Mr.
I even called the
Parvin,
clerk and went over it on the screen with her.
Mr. Parvin, have you tried to go over that with him? Just show him how
I've
it
shown on the
works?
filing system. Honestly, I've had some issues there as well, where even if it gets there, it goes to a pile. I find it much easier just to deliver directly to the clerk with the courtesy copy, because I know then there's a response that's been received. You don't always know it's been received if you use the action online. But
Right. So the colloquy, it sounds like there's an issue here because I guess Lane's been having to have stuff personally served, and these government employees don't like that. So they want him to use the e-filing system. And of course, the judge says there's no problem because somebody told me it's no problem. But then Lane's own attorney is saying, actually, no, I've had problems too. And so that's I have a problem with that as well. But we could talk about my problems from before I was a lawyer and what I had to deal with later. But it's reminiscent of the same kinds of stuff that I heard when I was representing myself as well. The deep state, the administrative state, the bureaucracy. Look, these people are 100% funded by the taxpayer. I think the only chance that you have in cases where your rights are being violated probably is recalls. I can't think of anything else that would possibly work.
I believe, I understand the court will understand if it doesn't get to them, there's a reason you tried. I don't think the court's going to hold that against you, Mr. Myers.
The only thing I could see on there is it says emergency judicial action.
You don't need that.
Right.
There's a way to do it. It's just always, I should say, more
I don't know if it's
complicated.
because I'm pro se and they won't let me just send things directly.
No, it's only one system.
Well, it won't matter now because they're going to arrest me and play games.
Mr. Parvin, what would you, I wouldn't, if you have problems with the system, how do you do it?
Well, it's not that I've never had problems filing anything.
Right.
I've had problems where it thinks it sent it to someone, but it doesn't. It maybe it's just on someone's desk or doesn't get printed out, or it's in a list of documents. So I find it best, although as the attorney, it's easier for me to just follow up with for example, the state or the chambers and say, did you get this? And sometimes I say, could you please email me a copy? And that way I have it. But I understand Mr. Myers' situation is a little different. I think it'd be best to use the system where it gets to your court at some point, and if the court does not have it, I inform Mr. Myers it's still filed on time, and then the court would just explain, okay, it's not going to use that against Mr. Myers simply because it finally got to you at a later time.
So the issue that, it's important that we get copies. What I don't want is for Mr. Myers to email us all this stuff that's
Right.
not just a document. If we don't get a copy, we don't know it's filed. We don't keep a running, we don't look at every case all the time.
Right.
We take action because something's served on us.
And that is the problem I've had before, when I thought I didn't follow up and I thought it was served on our court and it wasn't. Again, it was easily fixable because we just got an extension of time limits. But I understand Mr. Myers' concerns. That does happen sometimes where you never know for sure if the person receives it. You don't get confirmation unless it's
That's right.
email.
All right, so I'm going to amend my order from yesterday that Mr. Myers can provide a courtesy copy. when you email me, Mr. Myers, you also have to copy the state prosecutors, okay?
Right.
I guess,
All right.
I
You
feel like
have-
this
no,
hearing is,
Right. So that's because you can't have ex-party communications with the judge, because that could create the appearance of impropriety, like you and the judge are buddies. So when you do have a situation where you want to contact the judge, you always have to make sure the other party knows about it. And obviously, even better, is there to protect their interests, rights, and obligations and duties as well to their client if you're a lawyer.
Hold on.
I mean,
We're just talking about procedures.
but I know I'm going to get arrested when I walk out and they're going to try to hide me from my computer. So I
Miss-
can't even,
You're
so
gonna get a new hearing on that.
how am I going to be able to even file anything in this case if I'm in jail?
It's a
I
real
don't have any
problem.
jurisdiction over that. We're talking about this case and what we're doing today.
You know what's going on. You saw the
Nope.
slap.
Yeah, and I would take exception to that. If I was the judge, I do have jurisdiction. Trust me, if I'm the judge, I have jurisdiction over that. And I can, right on the spot, I could order an emergency hearing to find out what's going on. I know that I would have that power in Texas or California. I have inherent sua sponte power. So I take exception to that. Me personally, but again, I'm not an Arizona lawyer. It could be different there. Maybe the judges are limited in the power they have to control court proceedings and basically trial by ambush, which is what it sounds like is going on here.
Be a slap in the next one.
The court's not gonna read everything in 30 seconds.
Okay.
It takes time.
Mr. Myers, we're talking about procedures in this case, okay? I'm trying to help you so that you can hold on, so you can represent yourself.
But I'm
And
wondering
hold
if
on.
that's the thing.
You don't talk over me.
I'm not apologizing. Go ahead.
I'm just trying to find a procedure so that you can file things properly so that I get notice. But I don't want to hear the arguments and the invective towards the other side.
I don't.
So I will amend my order that when you file something, you could email the state's attorneys, Ms. Stiles, all right? So you should never email something to a judge without the opposing party knowing about it.
Talking about like when you add the names? CC,
Yes.
right? Okay.
CC, yes.
And I'll suggest, Mr. Myers, no commentary. What I do, you
get
simply add the motion, you say, this is what the motion is in the body, that's it.
Right. Then we'll make sure we
Yeah,
have
that's
it.
true.
But I don't want, you've added a lot of stuff in the motions that,
Yeah, because this is all a BS case.
okay, but it's not proper. I can only consider what's filed in the court file.
I understand what you're saying, 100%.
All right. So are we ready to proceed to the defendant's motion to represent himself?
Yes, Your Honor. Mr. Myers, you have filed everything, right? So even if you're brought in custody, you have nothing else to file at this point.
As to the motion to represent yourself.
You're talking about the motion to represent myself.
Right.
I filed the notice of appearance with
Yep.
you. That's what we're
Okay,
having
I'm
a
saying
hearing
even your
on.
slap motion's filed,
My
everything's
slap
filed.
motion's filed, but I had other stuff, Rule 15 and all that, but they knew what they were doing. This is dirty
Okay,
tricks.
I think
Okay.
everything's filed, Your Honor, where we could proceed.
All
and
right.
That way you're not harmed.
My thing is if you let,
Come on, Mr. Myers, we're proceeding.
I know, he was saying that initially a few minutes ago that, there was an option of, waiting a little bit to see, because, they might pull more tricks out of their sleeve. So the thing is that in order to make sure that I have an attorney, but my thing is I'm loath to do that because I want the slap motion heard immediately. So if I don't go pro se right now, that would delay you being able to act on the slap. You know what I mean?
Correct.
But it's also knowing that you left the house today with your wife's car half fixed, and now I got to go to jail. You know what I mean? And my wife can't get to work as an attorney in town because this is the level they want to take it to. I don't know. You know what I'm saying? What's gonna?
Okay.
I have a
Now,
suggestion. Hold
now
on.
I have
Hold on.
serious concerns about these people being
Hold
ethical.
on. Your Honor, I will accept the appointment on the new charges, consider the fact it'll be a separate case number that will address that. That way I'll be appointed on the new case, if you're brought in custody.
Will it be brought
and you can
in?
Still, eventually. And then we'll do this again on the second
So
case.
yeah, there are no new charges pending.
Yes, there are. They're waiting in the
Hold
hallway.
on.
No.
You'll get an immediate court date on that.
There's a process. If you get arrested, then there'll be charges filed. They'll take it to the grand jury. If there's a true bill.
Well, how
you'll
would
be
I-
It's the
arraigned.
one where they got 10 days to get the grand jury. Okay.
So there's the new charges are not, they're not before me.
They're gonna arrest me when I walk out.
It's not before me.
But then I'm gonna
Okay.
go to jail and I won't be able to
Mr.
talk to you.
Myers, I was hoping it was already filed, like some sort of indictment. That wasn't the case. That's why I brought it up. Unfortunately,
Right.
it's not yet filed, which
That makes
means you have to
sense.
go through the process, which I believe I told you about 10 days.
My
We'll
car's
have-
sitting out there.
Okay. We're here on
Why
the
can't you
waiver.
be respectful and professional?
I'm trying to be.
No, not me and you. These over.
We're not talking about that.
We are though, because you know that as soon as I walk over here, and then I'm like, how am I going to be able to respond? If you say, if you need further briefing in the slap or something, and I can't do it, then I'm screwed.
No, it doesn't work that way. If you're in custody and can't respond, we'll give you additional time. We won't work that way. I'm not going to. No, it doesn't work that way. You're not going to be prejudiced in this case because you've been arrested on new charges.
Well, you're still prejudiced whenever you're locked up. I mean, first of all, emotionally, it's very difficult to work on a lawsuit or even think about your defense when you're worried about someone trying to, beat you up or, someone messing with your chow. These guards obviously aren't going to like him because, it's the prosecutor, and the prosecutors are friends with the cops, and the cops are friends with the correctional officers. I mean, there's a lot more at play here than meets the eye, guys. And I am fearful for Lane. And honestly, if I was a judge, I would take all of these things into consideration. Honestly, from what I've seen so far, I don't see any basis, if this was California or Texas, to charge him with harassment or any of this other kind of stuff. I mean, yeah, Lane flies off the handle. He's definitely does not have my demeanor as a lawyer, but he's not a lawyer. And so far, I've been very impressed with what he's been able to accomplish, considering that he's not a trained attorney with any real legal education that's formal. Let's keep going.
Okay.
Yeah, they're going to say that I committed a felony while I'm felony for a bond
That's different.
for making a meme.
That's different. That's different than your slap motion. All right.
Well, I'm going to put a new one on the next one.
Okay, you can do that if there's new charges filed. That's not what we're here for today. Let's
Well,
really.
I'm scared that if I give up my right now, I won't be able to have it in the next case.
Have your right to rep attorney?
Yeah.
No, it's a separate case. I accept it. I'll accept the appointment on the new.
So you get a new attorney in the new case, and then you can waive your right to that attorney,
Okay.
and you can file a slap motion in that case.
So there'll be CR over here, CR over here,
correct.
judge whatever, judge or you maybe you.
Same
Okay,
judge.
so it'll be 14 over here, whatever the new over here.
That's
My
right.
understanding is the concern was I'm not ready to file a slap motion. I don't know if it's proper or not. It sounds like there is some merit, but I would have done it differently. And which means if I stay on this case, technically the court has to say it goes through me. That's why I'm withdrawing so that your motion will be filed.
That's what I'm trying to say.
Okay. All right. So, Mr. Myers, I can have you stand and be sworn by the clerk first. Then I'm going to ask you some questions about your waiver of right to counsel.
You solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
So this
All
is
right, have a seat.
Beretta.
Mr. Myers, I'm going to ask you a bunch of questions, okay? And it's just the rules I have to follow before I can make a decision to allow you to represent yourself. And they're very standard questions.
Okay.
And it's from Criminal Rule 6.1, okay? So, do you read and understand English?
Yes, sir.
What's the highest grade you finished in school?
12.
I think
Graduate high
so,
school?
Johnny.
Well, I have a
GD?
no, I have a college diploma and 2 technical degrees, a paralegal degree that I got in prison.
Okay. Are you under the influence of any drugs, alcohol, or medication?
Right now?
Yes.
No.
Have you ever been diagnosed with a serious mental illness?
No.
You have the right to counsel for all stages of the proceedings, including appeal. And if you cannot afford counsel, you have the right to a court-appointed lawyer at little or no cost to you. Do you understand that?
Yeah, so I can go back to a lawyer.
Correct.
Right.
If I allow you to waive your right to an attorney, do you understand that you can change your mind and request to have an attorney represent you going forward?
Thank you.
Is that yes?
Anytime moving forward later on, I can go for myself for a little while and then say, you know what, I want a lawyer.
Right.
Motion?
Yeah, you would file, or you could just say in court.
Okay.
All right. So do you understand you have that right?
Yes.
All right. Next, I want to talk to you about the risks of self-representation. First of all, I want to go over the charges. So you've been held over for trial on an indictment that was filed on March 7th, and there are 14 counts to that indictment. Counts 1 through 6 are each class 5 felonies. If the state can prove that you've been convicted of a prior offense, it takes you out of first-time offender status and makes you a category 1 offender.
Very scary.
Which means you're not eligible for probation. So if you're convicted, prison only.
So we call this a multiplier in California. And of course, with the 3 strikes law, it could potentially be even worse. 3 strikes and you're out.
Each one, the mitigated range is a quarter of a year, that's 3 months, and the Aggravated range is, well, excuse me, on count one is a quarter of a year to 2 years. That's a class 6. And then the others are all class 5s.
Wild.
Counts 2 through 6, where the sentencing range is a half year to 2.5 years. And then
I think so.
counts,
Speak life.
7 through 13 are class 1 misdemeanors, no prison available. There is probation available, or I could sentence you to 6 months on each. And as to all these, some of them may have to run at the same time, but some can run one after the other. So you're facing a substantial amount of prison. And then the last count 14, the stalking is a class 3 felony. Again, if you're a category 1 offender, the sentencing range is prison only 2 to 8.75 years. So you're easily looking at the possibility of a long time in the Department of Corrections. Do you understand that?
Can I say something back?
I want to know if you understand that.
Yeah, that's why I wanted to clarify something you said right at the beginning of that
Uh-huh.
little section.
Uh-huh.
About the felonies prior.
Okay. And you're under oath, and anything you say can be used
No,
against
I was
you.
wondering if you meant, do they have to be in Arizona?
No.
Yes,
They
I
have to,
understand.
they have to meet at a certain time period.
Yeah, they're
That-
26 years old.
Hold on, there is a way to strike it, but that's down the road.
Okay.
Okay.
So to answer the question corresponding to that little segment, yes, I understand.
Okay. Now, if you do represent yourself, you'll be held to the same standard as lawyers. Do you understand that?
Yes, sir.
And you, I believe you have a paralegal degree, you said, but you.
Well, actually, if you look at Balistreri versus Pacifica Police Department, you don't really get held by the same standard. The judges have to give great deference when addressing technical or procedural requirements. The Court of Appeals has a duty, and the lower courts have a duty to ensure that pro se litigants don't lose a hearing, a fair hearing on the merits of the claim due to ignorance of technical or procedural requirements. However, substantively, on substantive law issues, the judge is correct. And obviously I'm pretty sure that Arizona has to follow Balistreri and its progeny. So I disagree with that statement that a pro se litigant is held to the same standard as lawyers. And I definitely would take exception to that, but let's keep going.
You understand that your lawyer, Mr. Parvin, has attended and graduated from law school and has practiced as a lawyer for a long period of time. Do you understand that?
Yeah, my wife was a judicial law clerk for 8 years too, till they got her fired in this case.
Okay. So what I'm saying is, if you're represented by a lawyer, you'd be represented by someone who went to school for a long period of time and has practiced for a long period of time in this area and has a lot of knowledge and wisdom and experience that he can bring to bear in representing you.
What's the matter,
You're
you?
just simply not going to have
Crazy.
by not being a lawyer. Do you understand that?
Yes, sir.
All right. If you represent yourself, you'll have to do certain things like pick a jury. Have you ever picked a jury before?
Yes, sir.
You have? Okay.
And I won the case.
All right. You have to make opening and closing statements, and you'll have to cross-examine the state's witnesses and examine your own witnesses. Do you understand that?
Yes.
And you may find it difficult to make arguments to the court. Again, if you watch your lawyer do it, he's very professional and smooth, and it may be harder for you to do that than it is for him to do that. Do you understand that?
I do. You can go to school for 10 years and still not have ethics, though.
Okay, but that's not the question before us today. The question is training and experience. And what I'm trying to tell you is that if you represent yourself, you're giving up a resource of someone who's very trained in this area. Now, currently you're out of custody, and I understand that maybe you'll be in custody. If you're in custody, as the case proceeds, it's much harder to prepare your case
Obviously.
than it would be for your lawyer to represent or prepare your case. Do you understand that?
I do, and that's why I'm trying to figure out why couldn't they just do this all at once?
Okay. And things that are hard to do would be to subpoena witnesses, review disclosure, and interview witnesses. Do you understand that? Although we will make provisions to try to make that as clear as possible. It is just more difficult if you're in custody. Do you understand that?
Yeah, I understand the game.
It may be harder for you to file papers in court. Today, we've talked a little bit about.
So if you look at my comments, my legal research that I've been putting up at the top, Lane could challenge this pending arrest that's coming when he walks out of the courtroom as retaliatory. And the section I found says ARS section 12-751 sub B. So somebody take a look at that and tell me what you all think. I think if I was a lawyer in Arizona, I would probably file immediately for a habeas petition, and I would argue ARS section 12-751 sub B. What do you guys think? I'm going to keep playing. Let's go.
About the difficulty, we're trying to mitigate that, but you understand it may be difficult to file papers in court as compared to your lawyer who does it all the time.
File with court, you mean if I'm in jail?
No, just generally, just being
You mean throughout the litigation?
yeah,
whether
just being a
I'm-
pro se person,
Yeah.
it may be harder for you to do it
Get
than
them in and stuff, right?
all right. And then when you represent yourself, you're going to have to stand up and argue to the jury, and in your presentation, you may have less credibility than the lawyer would have. Do you understand that?
Not in this case, but yes.
All right. Well, you think I'm just telling you that's a possibility.
I
I'm not.
understand the optics.
Yeah.
Yes,
All right.
that's what you mean, right? The optics of it.
Yes, exactly. The service of an attorney can be of great value in determining whether the charges against you are sufficient as a matter of law, whether the procedures used in investigating the charges and obtaining evidence against you is lawful, including the lawfulness of any search, seizure, or police questioning. If an act you may have committed actually amounts to the crime for which it is charged, or if you have another valid defense to the charges, or if you're found guilty, whether you should be placed on probation, required to pay a fine, or sentenced to a term of incarceration, and whether appellate review could be justified. Do you understand that service of attorney can be of great value in determining those matters?
I do, and if it gets past the slap motion, you never know. I might have to get one.
Okay. And as we've gone over, if you're found guilty of the offenses charged, that you do face the possibility of being sentenced to a term of incarceration, even though you've given up your right to an attorney. Do you understand that?
Yes, sir.
Having gone over the risks of self-representation, is it your choice today that you still wish to waive your right to an attorney in this matter?
In this matter.
In this matter,
Right.
this CR matter?
Not to whatever they're going to do out there.
Correct, this case, this
Yes.
pending before us. And the answer is that is yes?
Yes, sir.
Has anyone promised you anything if you waive your right to an attorney and decide to represent yourself?
No, sir.
Has anyone forced you or threatened you in any way to waive your right to an attorney and decide to represent yourself?
No, sir.
Have you had the opportunity to discuss your decision to waive your right to an attorney with the attorney that's currently representing you?
I have. We didn't know this was coming though.
Okay, but again, do you think you need to talk to your attorney more before you decide to waive your right
Not
to a
in
lawyer?
this case.
Okay,
I have one concern, Your Honor.
Sure.
Is slap motion can be done any time, and that's the only concern I had. I didn't really feel comfortable filing that. What has a time limit that I'm worried about is a remand to the grand jury. I don't know when the transcript's coming in. That is a motion I would strongly recommend looking into filing. I don't know if Mr. Myers is capable of filing that motion in custody or even knows when he'll get it, but that's a strict time limit that really can't be waived by the court, although you can
That's
get
right.
extensions. I know how to do that. Mr. Myers may or may not know how to do that. That's my only concern. But again, I'm not going to file that slap motion. That's Mr. Myers' motion. That's why I need to be withdrawn. I don't know if there's a way to appoint me as advisory counsel and give me permission
Yeah,
just for that one
there
basis
sure is.
to look into the grand jury and file that
At least
one
in
motion
California,
only.
well,
there is.
if I grant his motion, I'm going to appoint you as advisory
As
counsel.
advisory, can I still file that motion on his
Well, hold
behalf?
on, no, because then you're his lawyer. Hold on. What's the deadline for filing a motion for remand is based on what date?
So it's 45 days after they receive the certified transcript. So
Okay. And you haven't received that
I
yet?
have not, but I'm worried Mr. Myers in custody would not know how to do that. I would. That's my main
Okay.
concern with this.
I could extend that to 60 days. Ms. Alves, do you have any objection to that?
no, and I said, I
Of
don't know
course
when the
not.
transcript's going to be ready, but they still.
Okay. All right.
We're not up against that timeline. So if they need more time even than that, we can always keep
Yeah.
adjusting it.
So for today,
But can he file it or does it have to be me?
It
No.
has to be you.
It has to be me.
But I will buy you time. I'm giving you time. Sorry.
yeah. Okay. So what we're going to do is today I'm going to enter an order, and I am
Absolutely,
ordering
Dirk.
that the defendant has 60 days to file a motion to remand once the defendant received a certified copy of the transcript of the grand jury. So that's 60
Very
days.
Smart
If we're
statement.
bumping up next to that, then Mr. Myers, you'll have to ask for additional time. Okay? What?
If I'm in jail
Yeah.
and they mail it to my house, I mean, How would I even know I got it?
Don't you,
Send me copies, even though advisory?
So the clerk's office sends out the copies, but we'll make sure that he gets it.
Okay.
He'll get access to all his
yeah, if
disclosures.
you're advisory counsel, I believe you continue to
If I
receive.
get notice of court dates, I don't know what the rules of disclosure are for that.
Okay.
So we will make sure that Mr. Parvin also has a copy of everything, so he gets everything so that he can go and discuss it with his client. So even though Mr. Myers is representing himself, he has his advisory council. So we make sure that we're still sitting things through Mr. Parvin.
Okay.
But that's not really representing myself.
Well, do you not want me?
Well, no, I'm
you have the
saying-
right. You could get me off. You want
I'm
me,
just
you
trying to
want-
make sure that like if they're gonna send stuff to him, is that what then he gets it to me?
Yes.
So,
He's your advisory counsel. He'll still be able to communicate with
but
you.
I'll also get sent a copy,
That's
right?
fair.
You should, correct.
State's gonna send to both, is my understanding.
There may be, if depending on his custody status, there may be different things with the media, but like we work with that all the time with people who are in custody representing themselves.
Okay.
So he will have access to everything.
The next thing is,
You hear that, right?
Yeah.
You heard what they said?
Yes.
Yeah, they're dirty.
Mr. Myers, to waive your right to counsel under the rule, you also have to sign this notice of waiver. So Leah, can you hand that to him? And it's on page 2 that you sign it, and I sign it as well, and then it gets filed with the clerk.
Do you want?
All right. The defendant, Mr. Myers, has signed the notice of right to waiver of counsel in open court. We'll put that date on there. The date is the 20th. Court makes a finding that after discussing the matter with the defendant and having observed his demeanor, that he has knowingly, intelligently, and involuntarily waived his right to counsel. The court will appoint Mr. Parvin as advisory counsel. And then we will talk about the schedule here. So there's that. That gets filed in open court. And
And Your Honor, I don't mean to interrupt. I just got a text message. Someone mentioned they can't hear any audio on the broadcast. I just want to make sure this whole thing was recorded with audio.
yeah, it says it's streaming active.
Okay, I'm not
So,
sure why I was sent that text message, but it's just what I was told.
okay.
It says can't hear any audio on the broadcast.
All right. Let's look at the schedule. So we have a motion to modify conditions of release scheduled for the 27th. And as to that, Ms. Stiles, I'd like, if you're going to present evidence at that, which I assume are videos, is that right?
That's correct.
Could you provide those copies to me beforehand so I can watch them beforehand, so we don't have to just sit and watch all of them? And then you're obviously going to disclose copies to the defendant as well, correct?
Yes, absolutely.
Okay.
Your Honor, how would I prepare for this in jail? Or you just told them to disclose all this. We went on, they could have told me this yesterday. They knew we were setting this hearing. They knew that I needed the evidence. We went over this yesterday. We made a big whole stink about making sure I had the disclosure so I could have due process ahead of the hearing. And now now I'm just being I was just appointed and under the understanding that, after this hearing today, they would provide it to me and I would go home and start getting, preparing for next week. Why they couldn't just bring this up at the next conditions of release hearing, you know what I'm saying? So that I could actually make cognizant arguments, because now they're just going to give you, it's like, I'm not even, the evidentiary hearing is a trial, is a hearing on the merits of their motion. Like, I don't even get to make arguments because they're going to put me in jail and avoid me. And that was the whole point. I wanted you to order them to disclose it to me. And you said, well, we got time for that. Miss Stiles, make sure you disclose it to him so he has time to get ready for the hearing next week, right? So they're saying, so all of a sudden you just asked her right here in open court, Miss Stiles, I assume you're going to be showing me this, that, or whatever. Could you send it to me, right? So that implies to the court right now that they knew as of right now, what they're going to send, or yesterday, or any of that, and they could have apprised me of this ahead of time, but they're waiting to right now to put me in jail, and then they're going to show you the evidence. I won't get to prepare for the hearing. I'll come there looking like a dumbass in a clown suit, and then not even, and then they'll be like, oh yeah. And I had no time to prepare, no time
That's
to argue, and my lawyer can't prepare because I just took them off the case. This was all a setup. They could have.
Okay. So, Mr. Myers, a couple things. First of all, if you're in custody next week, then there wouldn't be a need for a motion to modify conditions.
What are we doing?
And so we would put it off. Or if you're not able to prepare for it and we're there, you can tell me that you've been unable to prepare for it. What the state said yesterday, though, was all the videos that they're going to use come from you. So you've actually seen the videos.
I don't, but that doesn't, sure, that's not process that. So I'm supposed to assume which ones they're going to use. I don't know what I make hundreds of videos.
Well, hold on a minute.
So that's like saying,
hold on a minute. I would object heavily. First of all, that's not true. They could be modified. They could have been edited. So to make a statement like that is folly. I would say if I was a jurist on the bench, I would not make a statement like that. I think that statement was made in error. I think that there are many reasons why Lane needs to be able to see those videotapes. And I don't think that it's fair of a jurist to assume facts that Lane has seen this particular video, irrespective of whether or not he made it. Because, again, it could have been modified, could have been changed in some way or edited, or he could the context in which the video is presented, right? Because we see that all these prosecutors, at least in this case, they make these leading narratives that no one objects to. And it appears to me that these narratives that assume facts not in evidence, that are leading and argumentative, to large degree are being accepted as if they're true without even making an offer of proof. So that's disconcerting to me. I disagree with that wholeheartedly.
saying we're going to use something the color blue.
Okay.
That's not properly telling me. Now, if they're talking about for the whole case, like in the 14 counts, that's what I assume they meant. But if they're talking about specifically to prepare for the evidentiary hearing and they're going to bring up videos there, they need to tell me, because those are different. Because remember, now this is a hearing for the conditions of release, which means things that happened after the indictment, right? So now I can see for the things in the indictment, absolutely I should know because I have the indictment and I could read it in the police reports and all that, right? But I'm not. But the conditions of release hearing are things that have happened since then. I haven't been indicted, or I haven't been. You get what I'm saying? Given disclosure specific to, because when they filed their motion to modify, they didn't include no exhibits, no nothing. There was just, hey, we just want you to take our word for it. Trust me, he did this. And so,
problem.
and it was not even him; it was somebody else. And so what I'm saying is that how do I not for the indictment, which is like you said, you got time for that.
Exactly, Dirk.
Specific to this hearing, now they're going to put me in jail. And they could have. It seems like they know what they're going to present yesterday. Like she said in open court, it's going to be videos of me. Then she should have had no problem saying it's going to be the video that you made called this. It's going to be the video you made called this. It's going to be the video you made called this, or posted on this or that. No, videos. I got 586 videos.
Okay.
Which one?
So, Mr. Myers, at the hearing next week, if you have not been able to prepare for that hearing, we can put that hearing off. I don't have to decide it next week. So,
And
do you
Your Honor,
understand?
may I respond?
Sure.
Well, he
Your
stayed
Honor, so
locked
we've
up.
already been sending out the paper disclosure that has the information about all the videos that we have. We also are preparing, I believe it's going out today if it hasn't already gone out to Mr. Parvin, but we're sending him out, and now Mr. Myers will make sure he has access of all the videos that we're referencing. I am also happy to provide a list that I can send to Mr. Myers that specifically identifies each video that we're going to be doing. So even though he produced them, we're absolutely disclosing them, which is require that we disclose those to him, and we're absolutely doing that. We just couldn't give them all, immediately because we have legal obligations to do redactions.
So, Mr. Myers, when we come back next Thursday, if you think you haven't had a chance to prepare, we can always bump the hearing.
Yeah, because I've asked her 5 times for that. She said she has it now. What paper? She's mailing it to my house while I'm in jail. This is a game.
Okay.
I don't suppose the court has Friday available, so I can come too. I'm just trying to pick a date when I would have more time. As advisory counsel, Thursday is a really heavy schedule for me. If the court can do Friday on the 28th, I have an open schedule that day.
Well, the reason we said it yesterday is then we also had the victim's input and Mr. Parvin was here. I don't understand what
Yeah, I
happened to the
Well,
date
things
since
have come
yesterday.
up, and I was like,
victim.
Thomas, maybe if Mr. Myers needs me, I think his question is.
Advisory council, right?
Except advisory council, he should have been preparing to be there because advisory council should be at all the hearings.
We were, but we didn't know that now I'm gonna go to jail today.
Okay, hold on. So you'd rather do the 28th than the 27th?
That way I don't know how long, it sounds like it's gonna go longer than I expected. And the Friday, I have an open calendar where I can be here as long as it takes.
We still have 5 days notice for the victims, I believe.
I can text
Okay.
him right now.
Is she going to contact the victims right now?
Yeah,
Okay.
she's gonna reach out.
Yeah.
All right, let's wait for just a second on
I'd
that.
appreciate it. That way, if it does go 2 or 3 hours, I'm still available.
Okay.
I thought
Okay.
it'd be only a quick half an hour here.
Sounds like they'll make it work.
Okay, so we're gonna change the hearing on the state's motion to modify conditions of release from the 27th to the.
So I want also just to point out before we keep playing this, that I just sent you the link for This Is a Public Service. I'd appreciate it at right around 7:00 PM. You go meander over to his channel. We're going to have the hearing tonight. I think it's a bail hearing, if I'm not mistaken, or an arraignment, perhaps. I think it's the arraignment on the charges that he was arrested for today while he was in the process of doing his Feretta hearing with respect to him being able to try and litigate his SLAPP motion that he filed, his strategic lawsuit against public participation, alleging that the prosecutor's office is basically trying to silence him inter alia because a city prosecutor is, I guess, the husband of the alleged victim, and then went ahead and forwarded these charges to his buddy, allegedly, over at the county, and that this is basically like a conspiracy to try and silence Lane because these public servants don't like it, that he's holding them accountable. And so I think that is, in essence, the argument with respect to these charges and what this case is about.
28th, and that will be from 2 to 4:30. I'll have set aside for that. Okay, so, and again, Mr. Myers, if we get there and you can explain to me why you're not ready to go, then we'll address that. And obviously, Ms. Stiles can respond to that as well. And your SLAPP motion is pending before me right now.
For me getting arrested or anything won't, this case can work independently from them arresting me when I walk out?
Correct.
Because you need to see that, please. While I'm here, can I stand up for a second?
Sure.
You know, the SLAPP motion isn't really something that's, the criminal side of it isn't something that's really well defined yet. So like it's not really even in the rules of procedure. So I don't even know, is it going to be a standard 10-day? Because it's not even something they're required to respond to unless you order them to.
Correct.
So I don't know, is there a set period that you have to make your ruling
60 days.
before you order them whether to respond or not?
Oh, so I'll review it and I'll probably try to get it done this week. I mean, it just depends. And
say yes
if
or
I
no.
if I order them to respond, I'll do that fairly quickly.
Okay.
If I rule on it without making them respond, I'll also get that out fairly quickly. So,
And also, my understanding is you can rule on it without an evidentiary hearing, or you can, if you.
correct. I could rule on
I
it.
would
No,
prefer to have one.
press for transparency. SLAPP motions historically have been used only in civil cases. So it being carried over into a criminal case is a new area. And that's why Lane was saying, basically, look, this is a new deal. What's going on here? We don't even have a set procedural rule in place. But from what it sounds like, what I've gleaned so far, and Lane is a great legal mind, is that it appears as though the court has the right to decide whether or not the SLAPP motion has any meritorious base at all. And if it doesn't, it looks like the court, sua sponte, on its own motion, can reject it and not order the prosecutor to respond. So because it's a new area of law, if this judge is, pro-state or pro-prosecutor, look, most judges are former prosecutors. So, Lane, many people would say, is fighting an uphill battle on this. Let's keep going.
You know what I mean?
All right.
Unless you
So-
feel, you know what I mean?
Well, I have to make that decision. I've started to look through it. It's pretty long, like 25 pages or something. So I haven't read the whole thing yet.
I know.
Well, it's not your fault. I'm just saying, I started to look at it, but I haven't read, because you have a long paragraph as to each count. And I
mean,
got-
that's the only way I could do it. That's why I had to exceed, because
I'm-
it's like
I-
15
yeah.
pages for each count.
I'm
but I
not
couldn't make a
criticizing you.
79 to 80 page motion.
I'm not criticizing you. I'm just saying that it's going to take me a while to read it all. I have to decide whether to order the state to respond or not. And I know, as you said, that it's new to include criminal actions
Yeah.
in this anti-SLAPP.
Yeah.
But
Very
it's
interesting.
there, and we'll address it. Okay. And that's what happens. Maybe you'll be making some new law here.
That's what all this is about, because I'm the only one being charged for these videos. There's 500 videos of this same person that nobody else is being charged with except me. There's video. So what I'm going to go here, I want you to hear this right on the record. I'm going to go to jail right now, and there's going to be more videos made in the next 24 hours about the victim than there has been made in her entire life. So I'll be sitting in jail, and there'll be 500 new videos about the victim. Though she's going to get 500 new emails,
Myers,
500 new memes made about her. How does that protect the victim? It doesn't. This is a charade.
Well, it may be. I
You
don't
better
know.
right.
charge every single person.
He's
And
right.
I want you to address this on
I
the record,
agree.
because you said this yesterday, and we kind of talked about it for a second.
Slow down.
Slow down. I thought you said sit down. I apologize.
Slow down.
All right, so I would like to address this, something you said yesterday, because it's very pertinent as the matter. You're the trial judge, right? And so, I don't know when I'll be able to get back to my computer to notice adjudicated fact, but you ordered me, not asked me, you ordered me yesterday to remove your email from public posting, right? Because Gina's email is not, you know what I mean? And so, but in the period of time that it was up, right, you did receive emails, right? We went over that, and I mean, are those people going to be charged with crimes? You get what I'm saying? And so this is pertinent, and I want this on the record, because the judge in this case received emails as a state of Arizona employee at his .state.gov, and nobody's going to be charged for those emails with a crime by the same agency that's charging me for a crime for other people sending emails to some, not even emails I sent. So in this case, sir, will you be charging me with 14 felonies for those emails you received yesterday at Gina's email? Because that's what we're dealing with in this case. I didn't send the victim any emails. Other people did. I'm going to jail right now for something other
that's
people did. So in
pretty
that
scary.
case, when we come back on Friday,
It's a
you should have
public email.
however there should be a felony for each email you received, right?
So let me tell you how it works. Do you understand the separation of powers?
I do.
Okay. And do you understand who makes prosecutorial decisions? Do you understand that? Who makes prosecutorial decisions?
We're
Not
good.
me.
I know. But I'm saying, so I should expect to walk out there and get charged for all those emails you got.
I don't have any idea what they're.
Well, I mean, you would have reported them to the police.
I'm not going to tell you what I've done or not done. I don't charge people.
That's what I'm saying.
I hear cases.
Well, hold on a minute. If guys, hold on a minute. If the court did report these as criminal violations, at least in California, I believe under 170.1, he would have a duty to recuse himself because that would make him biased, right, guys? So that's interesting. Every time I listen to Lane, I got to tell you, when I first look, aside from his antics and outbursts, the guy is a legal genius. And I've known a lot of really great lawyers in my life. And I think that he is a guy who could very easily be one of the best trial lawyers in this country. He needs to read a couple books about understanding civility and learn how to deal within the courtroom decorum rules. And if he was able to do that, I think he would be unstoppable. I think the only reason, and you give me a bunch of ones if you agree, that he's being criminally prosecuted is because people don't like his personality and his attitude because it's so foreign to them. People in the legal community, they don't like it because it's foreign to them, because he's sort of like a William Wallace, right? Like a Scotsman. He's loud, he's crazy, man. He wants to give you a Glasgow kiss. But that's just his personality. And I don't think that should be held against him. I think that is protected speech. That's the way I look at it. I think demeanor, personality, bearing, those are all parts of protected speech. And I think he's being prejudiced because of his personality. And obviously, if he's been in prison, he could have serious PTSD. He may even have Tourette's or some other kind of autistic condition that we're not even aware of. And all that's being held against him, in my earnest opinion, as somebody who's practiced law for over 20 years. And I think that's something that I would consider.
You're appointed by the governor, right?
I'm a judicial branch employee,
That's what I'm
not an
saying.
executive
You're
branch.
not. What I mean is, over at like Justice Court, they get elected through votes.
Hold on. We have 3 branches of government. I'm in the judicial branch.
Right.
I report to the Supreme Court.
I understand.
The prosecutor is publicly elected. She's an executive branch official. Okay?
Right.
She does their thing. I do my thing. Different silos.
Right.
Okay?
And what I'm saying is you as a judicial officer of the state of Arizona, also people could make a video about you on there and say, oh, I don't think he wears nice shirts, or, you know, I don't like the ruling he made in that case, right? They're not going to get charged with the felony,
Okay.
but I am.
Right. Again, we're pending, we're addressing the charges that are pending before me in this case.
That's what I'm talking about. Because I'm being charged for things other people did.
All right.
That might be defenses, but. that's-
Okay, guys,
Yeah, we're
hold
not-
on
we're
a
not
second.
there yet.
Hold on. Look, we'll go ahead and circle. Okay, really quick. Lane's hearing is starting now on This Is a Public Services channel. So I want you guys, I'm not expecting you to stick around for me. I was just doing this because a lot of people have been emailing me and stuff asking me to cover this. So I'm doing it. But I'll cover more of it at a later date. You know, I promised my daughter I'd take her out tonight anyways, so I'll be watching it on my handheld. But I appreciate it if you guys would all say a prayer for Lane and his wife, especially, you know. And I don't know if they got kids, but, you know, like just say a prayer for him. Spiritual energy is super important right now. Going to jail is no joke. It's a horrible thing. I think he's getting railroaded, in my honest opinion. And, you know, I think the recall elections are in order at this point. And so go check them out. And then just really quick, I just want to just tell y'all, okay, let me take a look here. You're welcome, Greg B, Copster 5150, Riot Hoot. Go check them out. It's starting now. Yeah, I can already see people leaving the chat, which is totally fine. I'm not offended at all. I'm your servant. I'm just here to try to help you as best as I can. So with that being said, guys, I'll try to cover more cool stuff. I'm going to be in Houston, Texas, Willis, Texas, on Friday and Saturday night for the Paul Ehline Memorial Ride, where I help raise money for veterans of service-related cancer. Okay, so that's named after my father, who died from Agent Orange, toxic Agent Orange poisoning, two-tour Vietnam vet. He was in artillery, and he was my hero. And so the Leathernecks Motorcycle Club, those are my friends, and I help them with their motorcycle accidents and stuff like that. But I'm going out there just to help them out and you know, support veterans. So if y'all want to come join me in Willis, Texas, I think it's Conroe actually where I'm going to be. Come join me. But go check it out, guys. Go over to really quick. Let me drop the link one more time for you guys. Hopefully I still got it saved here. Go over to This Is a Public Service. Let them know that Mike Ehline sent you over at Ask Michael Ehline. Let him know. Type it in there that I sent you over there so he knows that you guys were watching my show, and thank him for all of his coverage and helping out Lane and his family. All right. So with that being said, Semper Fi, do or die. Make sure to like and subscribe. Make sure to save, because we never know when the thought police are going to take down this channel. I'll talk to you guys soon. All right. God bless everybody.